Good afternoon, everyone. This is the regular scheduled meeting of the Complaint Committee of the Sunshine Ordinance Task Force. Could we have the call, please?
Yes, Mr. Chair. Member Nee.
Here.
Nee present. Member Washburn.
Here.
Washburn present. Member Knebel.
Here.
Knebel present. Mr. Chair, we have a quorum.
Thank you. Is there any agenda changes?
There are no agenda changes, Mr. Chair.
Okay, could you call the first item, please?
The first item is approval of October 14, 2010 regular meeting minutes.
Move to approve.
Second.
The only addition I have is on line number 3 on page 2 of the minutes. Excuse me, number 5 of the minutes. Item number 3, the motion to find jurisdiction has been left out. It just says motion to jurisdiction.
I noticed that, Mr. Chair.
Okay.
I'll make the necessary corrections. Then.
Okay. With those corrections, we can move forward. Is there any public comment on the agenda? Seeing none, can we have the call?
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebel.
Aye.
Knebel, aye. Mr. Chair, there are 3 ayes.
Thank you. Can we call the next item, please?
Item number 2 is determination of jurisdiction on complaint filed by Kai Wilson against the private nonprofit North of Market Tenderloin Community Benefit District for allegedly not responding to an immediate disclosure request seeking the release of certain correspondence between staff and current as well as past members of the Board of Directors.
Thank you. Is a complainant here? Okay.
Hello.
So this meeting is about finding jurisdiction in the case.
Yeah.
So please provide facts and evidence for why we should have jurisdiction over this matter.
Okay.
You have 5 minutes.
5 minutes. All right. So I decided to file this for, I guess, community members that feel that, the complaint in general for community members that feel that something like a CBD should have more transparency. And then I, as a board member, ran into some issues where I felt that there should be more transparency. I know this is not to delve into the issue of me being illegally voted off the board, but at worst, this will be documented. So that's one of my goals. So basically, the reason I was told that they possibly would not have, you guys, the task force would not have jurisdiction. But the reason I decided to go ahead and make the disclosure request under the Sunshine Ordinance, and I'll just read from the ordinance, section 67.5, meetings to be open and public, application of the Brown Act. All meetings of any policy body shall be open and public and governed by the provisions of the Ralph M. Brown Act and of this article. In case of inconsistent requirements under the Brown Act and this article, the requirement which would result in greater or more expedited public access shall apply. There might be some spaces in between this. This is not in order. But then I go to D. I don't think it's the same section, but D, which defines a policy body, and it says policy body shall mean the board, 1, the Board of Supervisors, 2, any other board or commission enumerated in the chapter, 3, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors, period. And then 4, any advisory board, commission, committee, or board created by the initiative of a policy body. So under those 2, policy body, because the Board of Supervisors is a policy body, and this organization was created by ordinance or resolution of the Board of Supervisors, I mean, I think it's pretty, I guess, self-explanatory. I would say to continue that, it says any standing body of a policy body, any standing committee of a policy body, irrespective of its composition, policy body shall not include solely employees of City and County of San Francisco, any advisory board, committee, and council. created by federal, state, and grant whose members are appointed by city officials. And then so I took an excerpt, and because I was also on the board of or it's not board of supervisors, I wish, but on the board of this organization, I read the management plan, and it clearly states that the CBDs are enacted because they're approved by resolution of the Board of Supervisors, and that's the definition of a policy body. And so an excerpt directly from an email sent from in January 2006, the Board of Supervisors approved the resolution that authorizes the North of Market Tenderloin Community Benefit District as the owners association who will administer the North of Market Tenderloin Community Benefit, corporation to who will administer the North of Market Tenderloin Community Benefit District. So my claim, even with the city attorney's response, is that I am enacting the Sunshine Ordinance because I was refused information, and I am contending that they were, and it's on record, approved by resolution of the Board of Supervisors. So that's.
Thank you. Are there any other parties here to speak on behalf of the complainant? Okay, you have 3 minutes. Please state your name.
Yeah, good afternoon. Thomas Picarello, Tenderloin resident and an occasional participant in the North of Market Tenderloin Community Benefit District. And I read the city attorney's memorandum, and it seems to be contradictory. Clearly, complainant has alleged the violation of the Sunshine Ordinance, in addition to alleging violations of the Brown Act. If you read his opinion, he's saying that you do have jurisdiction. Secondly, the Sunshine Ordinance defines policy bodies as created by ordinance or resolution by the Board of Supervisors. CBDs could not exist without the Board of Supervisors creating them. Clearly, you do not want, and there's approximately 12 or 13 CBDs in the city already, and more to come. In fact, there'll be another one created right where we're standing today in City Hall, Civic Center. You don't want to privatize government and then deny citizens the right to participate in important policy decisions that these CBDs are enacting. They have $1 million budgets. They prescribe public policy. So it's your responsibility to comply with the Sunshine Ordinance and find jurisdiction in this case. Thank you.
Thank you. Are there any other people here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Please state your name, and you have 5 minutes.
Yes, my name is Elaine Zamora, and I'm the district manager of the North Market Tenderloin Community Benefit District. And it's just very simple. We do contest jurisdiction, and we feel that the opinion rendered by the city attorney supports that. Thank you.
Thank you. Are there any other parties here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
Ms. Zamora, please. Please approach the microphone. Does the CBD receive any money from the city? You have a contract with the
We have
city.
a contract with the city. Those are all private assessments that are gathered by the city.
But it's a nonprofit organization, correct?
That's correct.
Does it receive any funding from the city?
Only if we apply for a grant. We have applied for separate grants from, for example, community challenge grants, which are supported by the city. But other than grant applications, we don't receive any direct funds from the city.
Okay, are you operating now under any grant applications from the city?
At this time, no.
Thank you.
Mr. Moore, I have just one more question. We don't need exact amounts, but what is the approximate amount you've gotten under these grant acts from the city in a year?
One year, we received $55,000 from the Community Challenge Grant for a mural. We received a small operations grant from Mayor's Office of Economic and Workforce Development. That was approximately $25,000.
Okay.
And then we've received grants for other community organizations through MOEWD.
Okay.
Just filtered through the CV.
So in 2010, you have not received any grants, or have you received a grant this year?
I don't believe we have.
Okay, thank you very much. Any discussion? Questions?
According to, I haven't had a chance to really study this memo from Jerry Threet, but it looks like this body has to comply with the Public Records Act and the Brown Act. But because it doesn't receive $250,000 a year from the city, then it isn't subject to the Sunshine Ordinance.
And it's not specifically established under 12L.
Right, exactly.
Any other comments?
But I mean, I think the complainant could pursue this elsewhere, but not with us.
Okay, with that, we'd like to, now's the time in our deliberation where we want to give first the respondent and then the complainant time for rebuttal or closing remarks. So the respondent, if you have any closing remarks or rebuttal, you have 3 minutes.
Just again, we go by the opinion of the city attorney, and again, assert that there's no jurisdiction in this body.
Thank you. Complainant, you have 3 minutes.
Okay, that sounds good. I just, like I said, coming here today just to get this on record because these bodies are operating illegally. I was voted off in a closed session where my performance was discussed in a closed session. The outcome of this might not be to instruct this body of individuals to divulge the information, but there'll be a paper trail, and I will be pursuing this with the state because there are lies and mismanagement going on in these bodies, and it's a shame that the city enacts these bodies but has absolutely no jurisdiction over these bodies, and they're allowing them to be to run as for and nonprofit organizations, which seems a complete conflict of interest. They work very closely with the city. In fact, Lisa Pagan is orchestrating the inception of the Civic Center CBD. So it's really terrible that there's a money threshold that has to be passed, but not the orchestration of the entity. Like I said, they seem to be described as a policy body. I decided to take my complaint to their full board, which I was on. My performance was illegally discussed. You have individuals who are acting as district managers in this email that I forwarded to you all where I wanted various information because I felt that my safety was in danger. And it clearly states by E. Zamora that they're subject to the Brown Act and the Sunshine Act. So what she forwarded to you all stating that an email dated April 28, 2010, where they had no dealings with the Sunshine Act, she is in essence lying to active board members. There was also an email dated a year ago where all their information is public, and I understand that you're bound by doing various things, but this will be pursued in a different avenue, and I am happy that I got the statement from the city attorney because at some level these CBDs will be held accountable for holding information in closed sessions, making decisions about $1 million budgets in 2 to 3 minutes, barring public attendance from meetings and other items.
Thank you. Now the matter is back with the task force for motion deliberation.
Much respect as I have for the city attorney, and I think he weighed this question very carefully. But I think Ms. Wilson's counterpoint bears a lot of merit. In the ordinance, sections 67.3 D for David. Policy body shall mean 3, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. And as is pointed out here, even in the city attorney's memo from Mr. Threed, a CBD is a public-private partnership district created by resolution of the Board of Supervisors under state law. So even though it's private, I think that relationship is established, and I think it does qualify under 67.3D3 as a policy body. I will therefore move that this committee recommend a finding of jurisdiction to the full task force.
Do we have a second?
Yeah, I second the motion.
I definitely have feelings towards this as well, but in my reading, when we first got this memo and I went back, I think the wording that no members, exactly as was written, is that an owners association may not be considered a public entity. I mean, it should be considered a public entity or a private entity for all purposes. That kind of weighs more on me, so I don't think I could support this vote. Okay. Any other? Okay, we have public comment on the motion. Seeing none, vote by the task force.
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Caneva.
No.
Caneva, no. Mr. Chair, there are 2 ayes.
So the motion passes. So this will be calendared for,
The 30th of this month.
okay, this will be calendared for the regular task force meeting, the 13th of this month, to be seen in front of the,
30th.
30th, excuse me, of November, to be seen in front of the full task force. Can we have the next item, please?
Next item is the administrator's report. We have only, I think, 4 items through the chair, Nee. We have only 4 items for the 18th agenda. However, for the 30th agenda, we have 8+.
Well, that's why I want to have our meeting on the 18th, because otherwise...
One of the reasons that the number went up was because Mr. Ray Hartz amended his complaint. So the clock had to be restarted again, so it jumped to the next.
Those 2 were we're going to be on the 18th, but they're moved to the...
But yes.
Yes. Okay,
Thank you.
great.
That concludes my report.
Thank you. Comments? Is there any announcements? Oh, excuse me. Is there public comment on any item not listed on the agenda? Oh, excuse me. Sorry. Is there public comment on the administrator's report? Seeing none, can we have the next item, please?
Next item is announcements, comments, and questions in future agenda items for committee members.
Sorry, I think we have to go back to public comment.
Public comment for, you are correct. I stand correct. Public comment for items not listed on the agenda.
Is there any public comment on items not listed on the agenda? Seeing none, have the next item, please.
Next item is announcements, comments, questions, and future agenda items for committee members.
With that, I'd entertain a motion to adjourn.
So move.
Second.
All right, all right, so vote.